Science Uncut, presented by the Volkswagen Foundation.
So after a light lunch, I have the task to bring to you a quite heavy topic, and that is the legal aspects of the return of ethnological objects. And thinking about these legal aspects, one has to deal with two very fundamental difficulties. The first of these difficulties is the factor of time. Most objects of the ethnological collections we are talking about here have been brought to Europe quite a long time ago, when both moral and legal standards were quite different from the thinking nowadays. This change of perspective is one of the main reasons why the question of restitution has even arisen during the last years. However, from a legal point of view, this change of opinion concerning events in the very far past creates a huge conflict with the principle of legal certainty. Time passes, moral standards change, and legal rules may be modified for the future. But the rules for the past cannot simply be altered. As a matter of legal principle, events from the past must always be judged by the rules of their time and not by present-day ideas. It is for this reason that the legal situation sometimes doesn't fit the actual moral standards concerning issues of past injustices. As to be shown in the next 20 minutes, this is exactly how the situation turns out to be regarding the return of ethnological objects. The second point that makes the legal discussion about the restitution of these objects difficult is the lack of legal categories in Western tradition for the relations of states on the one hand and so-called indigenous groups on the other hand, who are often the ones to stake claims of restitution. Western legal tradition is based on the idea that we have either legal relationships between the state and individuals within its territory, or we have relations between one state and another, or legal relationships between two individuals. May these relations be of pure national or of international nature. So restitution of ethnological object issues might arise within these traditional forms of relations, as for example within states. We heard about that at concerning the example of Canada, or we have that especially in the United States concerning the return of artifacts of the Native American culture. Or they can arise between states, for example when Germany repatriated a fragment of a carved stone bird to Zimbabwe 10 years ago. However, relations between one state and an indigenous group within another state are simply not considered in Western-shaped ideas, both of national and international law. With these two problems in mind, I would now like to introduce the legal framework in which the question of restitution is settled. To understand the different aspects and the possible claims, one has to distinguish between two separate legal spheres in which restitution issues might matter. On the one hand, restitution claims can be dealt with under public international law. On the other hand, the different national rules of private law can be applied. Through public international law, the legal relationships between sovereign states are settled. Concerning the return of ethnological objects, the public international law therefore can establish claims of restitution from one state to another, but is neither able to directly address private or public institutions, such as museums, nor does it entitle other actors than states, as for example, indigenous groups. The private law, in contrast, does not address states, but private individuals. The state itself or its public institutions might therefore be subject to claims in private law only as far as any individual could be. As private law is subject to sovereign national legislation, there are different rules for the restitution of objects in every country. In the international context of the return of ethnological objects, normally the private law of the state in which the object is located now has to be applied. To make a long story short, at present, neither public international law nor private law does provide an enforceable title for the return of cultural objects to their places of origin in most cases. In public international law, it is above all the problem of time and retroactivity that excludes such claims under the present statutes. Generally, public international law provides two possible sources which can be relevant for our case: international treaties and international custom. In both fields, there have been considerable developments since the second half of the 20th century. One of the most important steps in the development of international law in the field of the return of cultural goods to their countries of origin is the UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property. Historically, this convention is heavily influenced by the decolonization in the 20th century. Especially the newly independent states had, on the one hand, a very strong interest in recovering those objects from their cultural heritage which had been exported during colonization, and on the other hand, were very concerned at the continuing loss of cultural heritage due to exploitation by looters at a time when they had relatively few resources to control it. Therefore, in 1970, the UNESCO Convention against illicit traffic of cultural property was adopted and came into force in 1972. However, at the beginning, it were mostly the post-colonial states which adopted the resolution, while the countries of the former European colonizers struggled a lot to do so. France, for example, signed the convention only in 1997, Great Britain in 2002, and Germany only 8 years ago in 2007. Besides many difficulties with the details of the convention and the implementation by the member states that are still unsolved, for hardly any of the return claims Western museums face today, the convention does apply, as it explicitly denies being retroactive. Therefore, only those objects can be covered by a restitution claim under the convention that have entered the country after the adoption of the convention. In Germany, for example, the convention can apply only to those objects that have entered the country not earlier than 2007. For those objects having left their countries of origin during colonization, the convention, therefore, is simply inapplicable. Besides the area of international treaties, return claims are sometimes discussed under the aspect of international custom. And in fact, it is often argued that customary international law, at least since the 20th century, prohibits the removal of cultural goods in occupied territories during armed conflicts. However, at this time again, the factor of time and of changed international thinking has to be considered. On the one hand, it is difficult to determine at what time exactly the international community of states mutually agreed on the interdiction of the removal of cultural property in wartime. It was not before 1954 that it was legally banned through international treaties. But even if one could argue that a mutual agree would already have existed in the times of colonization, it wouldn't have been applied to the colonized territories. In terms of public international law of that time, which was formed by Western ideas and Western political thinking, colonization was not an armed conflict in that sense, but simply an expansion of the colonizing country's own territories. The existing social structures in the colonized countries were not recognized as sovereign states. Therefore, even if the customary international law of that time had prohibited the export of cultural treasures of other states, this rule in any case would not have been applicable to the colonies of that time. Although today strong efforts in international public law have been made to prevent the exploitation of a country's cultural heritage, no written or unwritten rules for the export of cultural goods in colonial times therefore exist. Without any doubt, international treaties could establish legal claims for sovereign states to reclaim those cultural objects that were removed from their territory in colonial times. However, that kind of treaties would require the consent of all states involved in the restitution process. At present, such a consensus is not likely to arouse. Beside these rules of public international law, there are the provisions of private law which might apply to the restitution of ethnological objects. Although these rules do vary in the different legal orders, they normally have the idea in common that the owner of an object can claim the restitution from the possessor. That means the person who has the factual control over the good. For that reason, theoretically, claims can arise from the owner in the countries of origin to the current possessors, mainly ethnological or other museums in Europe. However, to enforce such a claim, the claimant has to prove his ownership. For 3 reasons that I will outline very shortly, this proof and therefore the enforcement of this kind of claims today is nearly impossible. All of these 3 reasons are related either to the cultural differences between the countries of origin and the Western countries or the topic of time. First of all, in many cases, it is not even easy to prove that the claimants, or rather their ancestors, were the legal owners of the respective object. On the one hand, in most of the cases, the state itself didn't exist when the object left its country of origin, so that for logical reasons it could not be the owner. On the other hand, private individuals or groups can prove their ownership neither. The indigenous groups the artifacts were taken from did not always have a tradition of property rights that corresponds with Western legal ideas. Without an equivalent to that idea, which dedicates an object to a single person, however, ownership that could base a claim of restitution can hardly ever be proved. But even if the applicable property rights of the state of origin do allow such a proof of original ownership, it can barely be furnished after such a long time. Private law in Western countries, on the one hand, provides different reasons why property rights can demise to another person without the consent of the former owner. And on the other hand, it uses the presumption that the current possessor is also the owner of an object. Therefore, the former owner has to prove that he didn't lose his property rights through all that years. As the provenance research in these cases turns out to be very burdensome and difficult, we heard about that, this evidence must regularly fail. But even in the case that the continuous ownership of an ethnological object can be proved in relation to a Western museum which now possesses it, in most Western countries the claim might not be enforced for reasons of time lapse or statute of limitations, as we call it in legal terms. In Germany, for example, after 30 years, the claim of the former or actual owner for restitution can be rejected by the opponent just for reasons of time. In the post-colonial context, therefore, at latest for these reasons, the countries of origin lack enforceable legal claims against Western museums to return cultural objects from their collections. Of course, those rules, both on the level of public international law and of private law, could be changed by the responsible legislators. Examples pointing in that direction can be seen both in international and in national law. On the international level, there is the Vienna Convention on Succession of States in respect of states, property, archives, and debts, which was signed in 1983, but did not yet enter into force as only very few states were willing to participate. The idea of the convention is to establish a legal claim for the so-called newly independent states, particularly against the former colonizers, for the return of certain objects, especially state archives. Cultural objects are not explicitly mentioned in the convention. However, even if this convention entered into force, as other treaties as well, it would not apply retroactively and therefore would face all the same problems concerning the factor of time mentioned before. On the other hand, we have the example of national legislation in the United States of America with the National Museum of the American Indian Act from 1989 and the Native American Graves Protection and Repatriation Act from 1990. These acts oblige federal agencies and institutions that receive federal funding to return Native American cultural items. That means human remains and cultural items such as funerary objects, sacred objects, or other cultural patrimony. These statutes have to deal with both of the outlined problems, the factor of time, as well as the difficulties of property rights as a Western concept. However, as it does not have international impact, but solely regulates legal relationships on the federal level of the United States, and therefore is in effect quite limited in its field of application, it is much easier to solve that problem than it is in international disputes. The problem of time is solved insofar as the statutes are indeed explicitly retroactive and do not limit the claims to be staked out within a defined period of time. The problem of Western ideas concerning the dedication of an object to a single person can be solved more easily within the United States as national legislation acknowledging Native American tribes as legal persons being able to hold property rights do already exist. So even if on the international level no consensus about the return of ethnological objects can be found, every single country would be free to pass national legislation obliging its museums to return such objects to the countries of origin. However, national legislation can hardly oversee whether the indigenous groups to which the objects belonged before their export are organized in a way that makes them addressable by national law. Therefore, in such international dimensions, it's more likely that only other states and not the groups within the states would be addressed. Nevertheless, it is not only this problem of defining the person of the claimant that holds back Western countries from passing such kind of statutes. Such a legal solution requires political consensus on the underlying moral dilemma, which is quite difficult to achieve considering the very different and in part contradictory points of view on that issue. One of the main topics in this debate is the confrontation of cultural nationalism versus the idea of common heritage of mankind, an item that is intensely discussed in the field of cultural property law. While the general concept of cultural objects having a nationality primarily argues for the return of ethnological objects, the idea of common cultural heritage of mankind pleads in contrast for the continuance in place in Western museums, as these organizations often have more resources to preserve the items and make them accessible to the public. However, this traditional antagonism does not reflect all of the potential conflicts rooted in the question of the return of ethnological objects as compared with other museum pieces. Ethnological objects exposed in Western museums often do not only have relevance as cultural artifacts, but stand out due to the religious, ceremonial, or spiritual significance for the group they originally derived from. This meaning is hardly considered in the general discussion of the allocation of cultural goods. Finally, it has to be considered that the restitution debate at the bottom is about more than just the question whether single objects have to go back to their countries of origin or not. Far beyond that, it is a debate about reconciling historical injustices committed during colonialism. The question whether the objects have to be returned or not, therefore, is not only a question of ownership and cultural or religious significance, it is also a question of guilt and redemption. Insofar, one might carefully draw a parallel to the restitution of Nazi-looted art. We heard about that this morning. And this restitution of Nazi-looted art has been put on a new basis nearly 20 years ago. However, regarding the experiences made in this field during the last years, it does not seem as if the solution that has finally been chosen turned out to bring peace and actually reconciliation. To my mind, this situation can be traced back to the fact that in the end, neither a mere political nor a statutory solution was found, but only an international agreement, the Washington Conference Principles on Nazi-confiscated art, which has the semblance of an international treaty, but is not at all legally binding for the signing states. The uncertainty about the legal impact of these principles has not only caused a lot of dispute and in part very costly lawsuits for both parties. In part, it has rather hindered than advanced a final act of regret and forgiveness. To conclude my outline and give an answer to the question posed with the title, under the current circumstances, the return of ethnological objects in almost all cases is not a legal obligation, but a moral dilemma. Legal answers for this dilemma, of course, could be found and established by the competent political institutions. However, what goes around comes around. If one chooses to statutorily regulate the return of ethnological objects to the countries or indigenous groups of origin, one has to accept the according rhetorical change in the discussion about restitution and the resulting change in decision-making structures. With statutorily regulation, restitution issues, on the one hand, become far more predictable and reliable, but on the other hand, as well, far more standardized. It is a political question whether a society does want to deal with a moral dilemma in that way or not. What can be learned from the example of Nazi-looted art anyway is that in any case it is advisable to clearly decide whether one wants to solve a moral dilemma with legal solutions or not. Otherwise, one has to face the risk to get the worst of both worlds. Thank you for your attention.